commercial institute presenting shorthand, dictation, legal and journal passages for upcoming SSC, PSC, Rail, High Court, District Courts exam at the rate of 80, 100, 120, 140, 160 and 200 words per minute.
Let's start. This appeal is filed against the final judgment and orders dated 28/06/2004 passed by the High Court of Kolkata in CO number 368 of 2004, whereby the single judge of the High Court allowed the revision filed by the respondents herein set aside the judgment and order dated 18/11/2002 passed by the Municipal Assessment Tribunal within bracket hereinafter referred to as the Tribunal Kolkata para. Notwithstanding the assessment made before the commencement of this act, the municipal commissioner on his own may amalgamate or separate or continue to assess as such as the case may be lands or buildings or portions thereof, so as to ensure conformity with the provisions of this section para. If the ownership of any land or building or a portion thereof is subdivided into separate shares, or if more than one land or building or portions thereof by amalgamation come under one ownership, the municipal commissioner may, on an application from the owners or co-owners, separate or amalgamate as the case may be such lands or buildings or portions thereof, so as to ensure conformity with the provisions of this section para. A newly constructed building shall become assemblable from the quarter following the date of issue of the occupancy certificate under the provisions of this act, provided that is such building is occupied before the issue of the occupancy certificate in contravention of the provisions of this act. Such building shall be liable for assessment from the quarter of following the date of its occupation, and notwithstanding any other action that may be taken under this act, such building shall not get the benefit of the rebate in the consolidated rate under subsection within bracket 5 of section 171 para. The municipal commissioner shall, upon an application made in this behalf by an owner, lessee or sublessee or occupier of any land or building, and upon payment of such fees as may be determined by the corporation by regulations, furnish information to such a person regarding the appointment of the consolidated rate of such land or building among the several occupiers within such land or building for the current period or the period immediately preceding para, provided that nothing in this subsection shall prevent the corporation from recovering the dues from any such person para. Regarding section 174 shows that it deals with two types of assessment for determining the annual value of land or building. One is in relation to the land on which the building is built, and the other is in relation to the open land, that is the land on which no building is built so far as former is concerned, that is the land on which building is built. It is governed by subsection within bracket 1 of section 174, whereas so far as the latter is concerned, that is open land on which no building is built, it is governed by subsection within bracket 2 of section 174 para. In the case of former, the assessing authority is required to take land and building as a single unit or determination of its gross gross annual rent which is responsibly expected to fetch at the time of assessment from year to year to illustrate if the building has some appurtenant land which is exclusively used by the owner for garden or oblique and parking the vehicles. Such building or oblique and land may fetch from rentals as compared to a building which does not have these facilities or has very small land pertinent to the building. In any case, such a building and the land cannot be separated for determining their gross annual rent. Such a case therefore would fall in subsection within bracket 1 of section 174. The annual value and gross annual rent of such premises have to be therefore determined as per the procedure prescribed in subsection within bracket 1 of section 174 of the Act para. The proviso to subsection within bracket 1 of section 174 deals with the case of transfer of the building and land. In such case, the assessing officer is required to take the amount within bracket sale consideration mentioned in the transfer deed as the basis for determining its annual value, and when to determine the gross annual rent of such premises as per the procedure prescribed in subsection within bracket 1 of section 174 of the Act para. However, in a case where no amount is mentioned in the transfer deed, the proviso says that the assessing officer is required to take the estimated market value of such premises as the basis and then to determine its gross annual rental as per the procedure prescribed in subsection within bracket 1 of section 174 of the Act. In a situation where the gross annual rent of any land or building or any part thereof cannot be easily estimated for the purpose of subsection within bracket 1 of section 174, then a procedure is prescribed in subsection within bracket 4a of section 174 as to how gross annual rent of such land or building is to be determined. Para. In all the situations set out above, the land or the building or any part thereof would be taken as single unit and not separate for determining the gross annual rental value. It is also clear from section 174 within bracket 2 within bracket small I and within bracket small I which provides that every building together with the site and the land 14 apparent thereto shall be assessed as a single unit. Stop. Para. However, the three proviso appended to clause within bracket small I of section 178 within bracket 2 also relates to building and the land, but with a different class of cases due to building's particular structure, its ownership and the manner in which such building or land is used by the owner. Para. If the factors set out in any of the three provisos were found present in any building or land, the assessment of such building and land has to be done as per the procedure prescribed in the provisos read with section 174 within bracket 1 of the Act. Para. Now coming to the later category of the cases, that is open land or land on which no building is built, it falls in subsection within bracket 2 of section 174. It says that the annual market value of open land would be fixed at 7% of the estimated market value of the open land. Stop. Para. We are therefore of the considered opinion that section 174 within bracket 1 and within bracket 2 operate in separate field. Both cannot be clubbed for determination of the gross annual rental value of land or building. In other words, both the sections have to be applied independently depending upon the fact as to whether the premises is a building with a land or it is an open land, and accordingly their gross annual rental value would be determined. Para. When the legislature itself has carved out two categories of cases, namely land or building, open land with no building thereon, and has accordingly provided different rates and different methods of assessment, it does not appear logical to club both the categories of cases. Para. It is a settled rule of interpretation in relation to taxing laws that a machinery provisions which enables the assessee to avail of the concession or benefit conferred by substantive provision in the Act, such provisions are required to be construed liberally within bracket C, G.P. Singh, Principles of Interpretation of Statutory Interpretation, 13th edition, page 5856. This rule applies to the case on hand, and hence benefit for the interpretation must go to the assessee rather than to the taxing man. It also serves the purpose for which section 174 is enacted. Para. Coming now, the facts of the case, we find that the High Court, while remanding the case, directed the tribunal to treat land and building of the premises as separate unit, and then to determine the gross annual value of the premises by applying section 174 within bracket 1 and within bracket 2 of the Act. Para. The view taken by the High Court does not comment its acceptance to us in the light of what we have held above. We, however, find that the tribunal followed proper procedure by applying section 174 within bracket 1 for determining the gross annual value. The tribunal's order therefore deserves to be restored. Stop. Thank you. Jai Hind. Jai Mera Bharat.